Hello viewers, welcome to the final part of LiveLaw's special segment on 100 important Supreme Court judgments of 2024. I'm your host Urvashi Chauhan and I'm here with the last set of 25 landmark judgments from 2024 that have left a significant impact on our legal landscape. If you haven't watched the first 3 parts yet, check them out on our YouTube channel. As always, I will give you a quick and crisp summary of each judgment while the citation and quorum will be displayed on the screen. Remember, for in-depth analysis and full coverage, you can always visit our website at www.livelaw.in. Let us start. After a legal battle of 9 years, a district judge aspirant got relief as the Supreme Court held him eligible for appointment after invalidating the decision of Manipur High Court to prescribe minimum cutoff marks for interview. This is the case of Salam Samarjit Singh versus High Court of Manipur at Imphal. A bench comprising Justices Rishikesh Roy, Sudhanshu Dholia and S.V.N. Bhatti noted that the relevant statutory rule governing the recruitment of district judges, the Manipur Judicial Service Rules 2005, did not provide for a separate cutoff for interview. Hence, such a requirement could not have been introduced through a full court resolution without amending the rules. Also, the requirement of a separate cutoff for interview was not specified in the advertisement and was introduced only after the written test, that too without intimating the candidates. The Supreme Court in the case of K. Arumugam versus Union of India ruled that sale of lottery tickets by a state government does not constitute a service but is an activity to generate additional revenue. Consequently, wholesale lottery purchasers are not promoting or marketing any service provided by the state, and their activities do not attract service tax liability under the category of business auxiliary service. Here, the bench comprising Justices B.V. Nagratna and N. Koteshwar Singh observed that the appellants who purchase lottery tickets in bulk from the state at a discount and resell them to retailers are not engaged in any activity that falls under the ambit of promotion or marketing of services provided by the client as per Section 65(19) of the Finance Act 1994. Next is the case of Chirag Bhanu Singh versus State of Himachal Pradesh, where the Supreme Court directed the Himachal Pradesh High Court Collegium to reconsider elevation of 2 district judges. The court emphasized that the Chief Justice of a High Court cannot individually reconsider a recommendation, reiterating that the decision must be taken collectively by the Collegium, which comprises the Chief Justice and the 2 senior-most judges of the High Court. The bench of Justices Rishikesh Roy and Prashant Kumar Mishra delivered this judgment. Next, we come to a judgment from the bench of Justices Bela M. Trivedi and Satish Chandra Sharma. In the case of Abhishek Banerjee and another versus Directorate of Enforcement, the top court held that PMLA takes precedence over Code of Criminal Procedure concerning summoning of individuals. In this case, the bench dismissed appeals filed by Trinamool Congress MP Abhishek Banerjee and his wife Rujira Banerjee challenging summons issued by Enforcement Directorate requiring their appearance in Delhi in connection with the coal scam case. Next, we come to Dhanraj Aswani versus Amar S. Mulchandani. The bench comprising the then CJI Chandrachud, Justices J.B. Pardewala and Manoj Mishra was here dealing with the legal issue whether anticipatory bail can be granted when the accused is arrested in another case. Here, the Supreme Court held that an accused already in custody in connection with one case can apply for anticipatory bail in connection with another case. In an interesting development in the case of Ashok Kumar Sharma versus Union of India, the top court dismissed a petition seeking suspension of military exports from India to Israel amidst the ongoing conflict in Gaza. The bench comprising then CJI D.Y. Chandrachud and Justices J.B. Pardewala and Manoj Mishra held that the issue was beyond the jurisdiction of the court and that decisions regarding military exports fall entirely within the domain of foreign policy, which is the prerogative of the Government of India and thus cannot be interfered by the judiciary. Moving further with the case of Javed Ali M. Syed versus State of Gujarat. Here the bench comprising Justices Rishikesh Roy, Sudhanshu Dholia and S.V.N. Bhatti ruled the alleged criminal involvement of an individual does not warrant demolition of a legally constructed property. It underscored the importance of adhering to principles of the rule of law in such matters. In a significant judgment under the Arbitration and Conciliation Act, the top court clarified that an application for extending the time to pass an arbitral award is maintainable even after the statutory period of 12 months or the extended 6-month duration has expired. This was held by the bench comprising Justices Sanjeev Khanna and R. Madhavan, and the title of this case is Rohan Builders India Pvt Ltd versus Berger Paints India Limited. Next, coming to the important judgment where the Supreme Court granted bail to former Delhi Chief Minister Arvind Kejriwal in connection with the FIR registered by CBI in the Delhi liquor policy case. A bench comprising Justices Surya Kant and Ujjal Bhuyan delivered the judgment on 2 petitions filed by Kejriwal challenging his arrest and seeking bail in the CBI case. The bench agreed to grant bail, citing that charge sheet had been filed, the trial was unlikely to conclude soon, and continued incarceration would infringe upon Kejriwal's right to personal liberty under Article 21 of the Constitution. The title of this case is Arvind Kejriwal versus Central Bureau of Investigation. Setting aside a controversial Madras High Court judgment, the Supreme Court in the case of Just Rights for Children Alliance versus S. Harish clarified that mere storage of child pornographic material without deleting or reporting it constitutes an offence under Protection of Children from Sexual Offences Act or the POCSO Act. The High Court had earlier held that storage without intent to transmit did not qualify as an offence, a view the Supreme Court found to be grave misinterpretation of the law. Significantly, a bench of then CJI D.Y. Chandrachud and Justice J.B. Pardewala also ruled that even watching child pornography over the internet without downloading it amounts to possession of such material under Section 15 of the POCSO Act. Next, we proceed with the top court's ruling in Fuleshwar Gope versus Union of India, where it clarified the strict interpretation of procedural timelines under Unlawful Activities Prevention Act. The court emphasized that when a statute prescribes a timeline using the word shall, especially in laws like the UAPA, it is not a mere technicality but a mandatory requirement. The bench of Justices C.T. Ravi Kumar and Sanjay Karol in this case made these observations while addressing the issue of grant of sanctions under Section 45 of UAPA along with Rules 3 and 4 of the 2008 rules, particularly in light of divergent views among high courts on this matter. The apex court, while granting bail to former Tamil Nadu Minister V. Senthil Balaji, reiterated that stringent bail laws must be balanced against the principle of fair and timely justice, ensuring that pre-trial detention does not amount to punishment. A bench comprising Justices Abhay Oak and Augustine George Massey ruled that the higher thresholds for bail under stringent penal statutes such as PMLA, UAPA and NDPS Act should not be used as tools to incarcerate individuals indefinitely without any trial. The bench comprising Justices B.R. Gavai, Arvind Kumar and K.V. Vishwanathan ruled that the mere existence of a benchmark disability does not automatically disqualify a person from pursuing medical education. The court emphasized that unless the Disability Assessment Board certifies that the candidate is incapacitated from studying the MBBS course, such individuals cannot be barred solely based on quantification of their disability. Also, in this landmark decision from Omkar Ramchandra Gaun versus Union of India, the court clarified that a negative opinion from the board is not final and remains subject to judicial review until dedicated appellate mechanisms are established. Moving ahead, a bench composed of the then CJI Chandrachud and Justices J.B. Pardewala and Manoj Mishra in Sukanya Shanta versus Union of India delivered a landmark judgment addressing caste-based discrimination in prisons. The court here struck down provisions in the prison manuals of several states that assigned jobs to prisoners based on their caste, declaring such practices as unconstitutional. It also laid down crucial guidelines to ensure the prevention of caste-based segregation and division of labor within prisons. Moving ahead, a bench comprising then CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra set aside the judgments of various high courts that had ruled against the applicability of Taxation and Other Laws Relaxation and Amendment of Certain Provisions Act 2021 for extending time limits to issue reassessment notices under the Income Tax Act. In this case, titled Union of India versus Rajiv Bansal, the top court allowed a batch of 727 appeals filed by the Income Tax Department, holding that the provisions of Act validity extended the time for issuing reassessment notices. This decision reaffirmed the legislative intention of the Act to provide relief during unprecedented circumstances like the COVID-19 pandemic and clarified that scope of TOLA in relation to procedural timelines under the Income Tax Act. Coming to another important judgment, sending a strong message against the trend of bulldozer justice, the bench of Justices B.R. Gavai and K.V. Vishwanathan held that executive cannot demolish the houses or properties of persons only on the ground that they are accused or convicted in a crime. The court also held that public officials who demolish the properties in such a manner should be held accountable, and that permitting such action by the executive is contrary to the rule of law and also a violation of the principle of separation of powers, as it is for the judiciary to pronounce on the guilt of a person. Next, we come to the case of Manisha Ravindra Panpatil versus State of Maharashtra, where a bench comprising Justices Suryakant and Ujjwal Bhuyan granted relief to a female sarpanch who was disqualified on technical grounds, underscoring the systemic discriminatory attitudes faced by women representatives at all levels of administration. The court emphasized that removal of an elected representative, particularly a woman from a rural area, should not be taken lightly. It stressed the need for a more inclusive and sensitive approach towards women in governance, recognizing the challenges they face in overcoming deeply entrenched biases. A constitution bench of the Supreme Court by 4:1 majority upheld the validity of Section 6A of Citizenship Act, recognizing the Assam Accord this year. The quorum comprised the then CJI Chandrachud, Justices Suryakant, M.M. Sonduresh, J.B. Pardewala and Manoj Mishra. CJI Chandrachud in his judgment said that the Assam Accord was a political solution to the problem of illegal migration and Section 6A was the legislative solution. The majority held that Parliament had the legislative competence to enact the provision. The majority held that Section 6A was enacted to balance the humanitarian concerns with the need to protect the local population. The Apex Court in Society for Enlightenment and Voluntary Action versus Union of India suggested to the Parliament to consider outlawing child betrothals by amending the Prevention of Child Marriage Act 2006. Since PCMA does not deal with child betrothals, the court noted that it can be used to evade the penalties under the Act. The bench comprising then CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra issued various guidelines in this case for the prevention of child marriages, but it refrained from deciding the issue whether Prevention of Child Marriage Act 2006 overrides personal laws which sanction such marriages. In another important case, the Supreme Court set aside the order of NCLAT that had closed insolvency proceedings against EdTech giant Byju's following a settlement with BCCI for around 158 crores. The bench of then CJI Chandrachud and Justices J.B. Pardewala and Manoj Mishra held that NCLAT had erred in invoking its inherent powers under Rule 11 of the NCLAT Rules 2016 to allow withdrawal of the insolvency application. The court emphasized that since a specific procedure exists for withdrawal of insolvency applications, NCLAT could not rely on its inherent powers to override the established process. The title of this case is Glass Trust Company LLC versus Byju Ravindran. And now let me tell you about a crucial judgment where the Supreme Court addressed the need for effective legal aid to prisoners, emphasizing that legal aid to the poor should not be poor legal aid. This was in the petition filed by human rights activist Suhas Chakma seeking measures to ensure that prisoners receive a free and timely legal aid. A bench comprising Justices B.R. Gavai and K.V. Vishwanathan directed the High Courts to consider issuing practice directions to all courts mandating inclusion of a cover sheet in all judgments involving convictions, dismissals and bail applications. This cover sheet would inform convicts of their right to access free legal aid for pursuing higher remedies. Next, the Supreme Court in Anjum Kadari versus Union of India, through a bench comprising the then CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra, upheld constitutional validity of Uttar Pradesh Board of Madarsa Education Act 2004 and set aside the Allahabad High Court's judgment which had struck it down earlier. In another important judgment, the Apex Court held by a majority of 7:2 that all private properties cannot form part of material resources of the community which the state is obliged to equitably redistribute as per the directive principles of state policy under Article 39B of the Constitution. The court held some private properties may come under Article 39B provided they meet the qualifiers of being a material resource and of the community. In a groundbreaking move towards fostering inclusivity and eliminating discrimination, the Supreme Court in the case of Om Rathod versus Director General of Health Services underscored the importance of providing equal opportunities for persons with disabilities in the medical field. The bench comprising then CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra granted a candidate suffering from muscular dystrophy the right to participate in the ongoing counselling of NEET UG 2024. The court had emphasized that persons with disabilities must not be viewed with sympathy but recognized as integral members of society. Coming to another landmark judgment where the Supreme Court affirmed authority of officers from the Directorate of Revenue Intelligence to issue show cause notices and recover duties under the Customs Act 1962. The court ruled that DRI officers are recognized as proper officers under Section 28 of the Customs Act, thus empowering them to initiate such actions. This decision was rendered in the case of Commissioner of Customs versus Canon India Private Limited, and the bench consisted of then CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra. The bench clarified the extent of powers granted to DRI officials in the enforcement of customs laws. And lastly, in the landmark case of Aligarh Muslim University through its registrar Faizan Mustafa versus Naresh Agarwal, the Constitution bench comprising the then CJI Chandrachud, Justices Sanjeev Khanna, Surya Kant, J.B. Pardiwala, Dipankar Datta, Manoj Mishra and S.C. Sharma addressed the crucial issue of whether Aligarh Muslim University qualifies as a minority institution under Article 30 of the Constitution. The bench, in a historic 4:3 majority decision, overruled the 1967 judgment in S. Aziz Basha versus Union of India, which had previously held that an institution incorporated by statute could not claim minority status. With this precedent overturned, the matter now moves to the regular bench, which will determine whether AMU qualifies as a minority institution. This ruling opens the door for a fresh interpretation of Article 30 and its applicability to institutions established by law, potentially setting a new benchmark for minority rights in India. And with that, we come to the end of LiveLaw's special series on 100 important judgments of Supreme Court from the year 2024. Please make sure to watch all the parts, like, share and subscribe to our channel. Do leave your views and suggestions in the comment box. Thank you for watching.